Hello, my name is Mike Meyer, and I will tell you about work authorization for your spouse in the United States. Let's assume you obtained a work visa. Let's say you obtained an L1A manager visa. You're being transferred as a manager to the United States, and your spouse and children are coming with you. Here's the good news. If you have an L1 visa, your spouse, your husband or wife, will be able to work on an L2 visa. However, your spouse, he or she, will have to apply for a separate work authorization, a so-called EAD or I-765. The I-765 is the form that is used to apply for such kind of work permit. You can only apply for that work permit once you are, or your spouse in this case, is in the United States. That is, you may have the approval for your work authorization or for your work visa before. However, your spouse can get a work authorization only once you have entered the United States and you have an I-94 card that evidences that you entered the United States and are legally present in the United States. Let's say you have an E visa. Let's take an E2 visa. Also there, your spouse will be authorized to work in the United States with an EAD or with an I-765 work authorization that can be applied for once you enter the United States. Those work authorizations for spouses of L1 and E2 and E1 visa holders apply to any kind of occupation. That means your spouse can work at McDonald's and flip hamburgers, or your spouse can work in a highly specialized profession such as engineering. These work authorizations only apply to spouses. They do not apply to children. Unfortunately, spouses of other visa holders are not authorized to work in the United States. Let's say you obtained an H-1B professional work visa. Your spouse will not be authorized to work on his or her H-4 visa. Let's say you are a journalist and you're in the United States on an I visa. Your spouse will not be authorized to work either. However, if you are in the United States and you apply for a green card, for example, through the labor certification process, and we have a separate video on that, then once the labor certification is approved, there's an I-140 immigrant petition, and then at some point an I-485 adjustment of status is filed. At that point, your spouse can obtain employment authorization, and even your children can obtain employment authorization. Now the question is, what can your spouse work in the United States? Well, in the United States, it's quite common to look for a job through the internet nowadays, and two websites are monster.com, which is www.monster, yes, just like Frankenstein's monster.com, or careerbuilder.com, careerbuilder.com. If you happen to be in a small town, well, you should be looking at the employment ads in your local newspaper in order to find employment for your spouse. And as I said, the work authorization for your spouse is unlimited. It can be for any kind of job. How long does it take for your spouse to obtain the employment authorization? As I mentioned, your spouse first needs to enter the United States and have an I-94 card. If you file immediately for the EAD or the form I-765, processing time is approximately 3 months. And it does require a so-called biometrics appointment, meaning after you have applied for the work authorization, there will be an appointment at a USCIS application support center where your spouse has to give fingerprints and a photograph is taken. When your spouse applies for a job in the United States, please pay attention to a few cultural differences. For example, what does a resume, a so-called curriculum vitae, look like in the United States? It's usually very different from other countries. For example, in Germany, applicants usually attach a photograph and say what their parents were doing and their date of birth. Well, you don't do that in the United States. I can't explain to you here what a resume looks like, but please look for samples on the internet. In general, a resume in the United States emphasizes what you can do and what your specific experience is. Nobody is interested, at least not in a resume, in your age or what your parents did or did not do. Of course, If your spouse happens to be in a status, for example, I mentioned the I status for a dependent of a journalist, or the H for the dependent of an H-1B holder in the United States, your spouse can always apply for a separate work authorization if your spouse is qualified for it. However, the choices are very limited. If your spouse, let's say, is an engineer by training, he or she could apply for an H-1B visa. But the reality is that H-1B visas in the United States are currently limited to 65,000 a year. They're only given out on the 1st of April and used up very quickly. So the H-1B professional work visa, even if your spouse has such an employment offer, may not be a good option. Another option would be, let's say you are from Germany. You come to the United States for employment and your spouse gets a job offer with another German company and your spouse has some specialized knowledge. Then your spouse may be entitled to a separate E2 work visa and can certainly get work authorization. Here's another tip. In the United States, voluntary work is very important. Your spouse may not be able to get a paying job, but he or she may be able to get an unpaid job. For example, at your local kindergarten, at church, at some kind of charity such as the Salvation Army. And oftentimes, if you work voluntarily, it can turn into a long-term or a full-time job. So my advice is, if your spouse cannot find a job, work voluntarily somewhere. Work for the Salvation Army, work at a homeless shelter. If you have more questions as to work authorizations, please consult an immigration attorney. Thank you.